We are jumping right into the deep end. Patricia Adams is standing before the judge in a yellow jail uniform, and the reason is heavy. She just gave birth behind bars only a month ago. But the judge isn't leading with sympathy. She's leading with a police report that says Patricia was hitting her own mother. Legal insight. In Texas, a Salt family household with a previous conviction jumps from a misdemeanor to a third-degree felony. That means she's looking at up to 10 years. The stakes? High. The mood? Absolute ice. Do you think being a new mother should impact a criminal sentence? Drop a yes or no in the comments.
Ms. Adams is in yellow because she recently had a baby a month ago at the jail.
So here's my question. I read this police report. Why are you hitting on your mom?
She's pregnant, so she is not able to go to various inpatient facilities, I'm told.
All right. And how far along are you in your pregnancy?
14 weeks.
So here's the thing. Anything that you do while you're pregnant, your baby is doing it too. Court will revoke you, sentence you to 4 years in the prison, give you credit for any time served. Excuse me, miss. Excuse me. No, don't be nervous. I mean, I can easily say don't be nervous. I understand why you're nervous because you're looking at 10 years in prison.
State of Texas.
Defense.
Michael DeLeon for Ms. Adams.
And are you Patricia Adams?
Yes, ma'am.
Counsel, have you received all discovery? Did you review it with your client?
We have, Your Honor.
Court will find that the state is in compliance with discovery. Ms. Adams, did you review the document entitled Application for Deferred Adjudication or Community Supervision with your attorney? Did you understand it? Did you review the true bill of indictment with your attorney? Did you understand it? Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented?
Yes, we are, Your Honor.
Did you review the court admonishments with your attorney? Did you understand it? And did you sign it in all the appropriate places?
Yes, ma'am.
Did you understand you're charged with assault, family, household, or member with a previous assault conviction? That's a third-degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. All right, after reviewing State's Exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you apply for deferred adjudication. Are we proceeding with sentencing?
We are, Your Honor. I do have one ask.
Yes.
Ms. Adams is in yellow because she recently had a baby a month ago at the jail. So she's currently not working right now. We were wondering if the court would be consider probating any of that fine, $1,500. That was my big ask because she's getting back on her feet as far as when she's out. And we're asking the court to grant her application for deferred and to allow her to do the TAP evaluation outside of jail.
All right. I'll probate the entire fine.
Here comes the he said, she said. Patricia claims she was protecting her dad, but the judge has the receipts. The police report paints a much darker picture. An argument over wanting to lay in the same bed, a punch face, and a stolen cell phone. Reaction. Watch the judge offer a jury trial the second Patricia starts backpedaling. That is a classic judge power move. It's her way of saying, if you're going to lie to me, let's see if 12 strangers believe you. Because I don't. The tension in the room just tripled. Who do you believe, the defendant or the police report?
So here's my question. I read this police report. Why are you hitting on your mom?
Your Honor, it was honestly, she assaulted my dad and I kind of acted on fear. I heard my dad screaming. So that's the reason why I kind of assaulted my mom.
Well, that's not kind of, and it doesn't mention that in here. And what, your father, is that Mr. Adams?
Yes.
All right. That's not what he says in this police report.
Well, that's what happened in the true situation.
Why are you living with them?
At the time I was staying with them because my dad had lost his Social Security and my mom was the only one that had Social Security and I was trying to be my dad's provider. So that was that situation and, money became an argument in that.
No, that's not what she's saying. She's saying you wanted to lay in bed with her and she said no.
Your Honor, I have my own air mattress. I didn't have to lay with my mom.
So, I mean, do you want a jury trial? Because it's sounding like counsel, she's saying none of this is true because in the report, it says that your mother had a swollen, busted, and bloody lip. that the officer immediately noticed it. She declined medical attention, and she stated that you had been staying at the motel with them. Victim states that you and her do not get along. It says that you went to lay in the same bed as the victim, and the victim told you to get up and move, and that caused an argument. Victim stated that she attempted to leave the location multiple times, but the suspect, that's you, was not allowing her to walk out the room. Suspect pushed victim multiple times away from the door, then punched her in the face one time with a closed fist. Suspect then grabs the witness's cell phone from the bed and fled the location. Witness 1 witnessed the assault and stated that suspect did push the victim and punch her in the face. Witness is disabled and bedridden. Victim provided information on suspect, and after running her information through CAD, it was determined she had a prior conviction of family violence. Then, are you saying that you didn't take your father's cell phone?
It was mine, and I had literally just got paid that day. So that's the only reason why I took my phone back.
All right, they're saying it's his phone because they said, I contacted the suspect over the phone with the phone number provided. That was witness's cell phone. And it says, you state, I'm not coming back to the location, and I did not assault the victim. And it says in here that you told them that the victim purposely hit herself to make it look like she was assaulted. And now you're telling me something different.
I didn't call on saying that she hit herself. I admitted to the police officer on the phone that I did assault.
No, that's not what this says, unless you're telling me the police officer just like, let me make something up in this story and put in here that she said she never hit her and that the victim hit themselves.
Judge, I've had extensive conversations with Ms. Adams about the particular situation. And while there's some dispute about the factual situation, overall, what it boils down to, and Ms. Adams agrees, is that she did hit her mother. That did occur. Circumstances around it are a little fluid, but overall, she does want the court to proceed with deferred adjudication. And she believes she can be quite successful on deferred.
How old is your mother?
She was born in 75.
All right, how old are you?
25.
You shouldn't be hitting on your parents. You shouldn't be hitting on anyone. And honestly, because you have a previous conviction for assault, I don't even know why you should be trusted around children, honestly, because it appears that you have a temper. And that hasn't been sufficiently addressed because you're here for another assault. And it's another family assault. State, you wanted to add something because you came up?
I did want to add that we're just requesting that the evaluation is recommended by the state be actually done in custody.
Okay. All right. Is there anything else?
Judge, we would just ask to have the evaluation done out of custody.
When's the last time you had employment?
During my around this time, the incident.
Doing what?
My father's providing the things for women.
All right, I can tell you right now, I don't allow people to be home health care providers for family members.
Well, I was looking for employment at fast food. I'm seeing.
Well, no. We start with what were you doing, and you.
The judge just went viral with this comparison. She calls home health care the new West telemarketing for felons. The breakdown. Patricia wants to work as a provider for her father, but the judge shuts it down. Why? Because you can't be in a caring profession when you have a documented temper and a history of family violence. Legal insight. Judges have broad discretion to set occupational bar conditions on probation. If the court thinks your job puts you or others at risk, they can legally tell you to find a new career path. No health care, no kids, no exceptions.
You said you were doing home health care providing work for your father. I don't allow this in this court. And to me, the home health care business is becoming akin to when we first started practicing. Everybody was working at West Telemarketing. Now, home health care provider is was telemarketing for felons. I don't allow people who are on felony probation to be home health care providers. They need to get a job. And home health care providers need to quit just looking at the bottom dollar where they're making a lot of money. Then they just hire random people to come in and watch people. Oh, you can watch them and we'll pay you $10 an hour. And then other things ended up happening. There's no way you should be in charge of caring for anybody because you have a temper that you cannot control. And how many children do you have?
Three.
And-
Three living children.
I'm sorry?
3 living children.
All right. And what are their ages?
I have a 4-year-old, a 2-year, well, a 1-year-old, and then a 1-month-old.
And who are they with now?
Right now they're with dad's custody.
All right. What does that mean they're in dad's custody? Was there a hearing? He has legal custody, or you just like, hey, I'm going to jail. Here you go.
Well, he's on the birth certificate and I'm incarcerated. So they stay with him and his mom due to my living situation with my mom.
All right. So that tells me that the grandmother.
Ouch! The judge is pulling no punches regarding Patricia's 3 children. Since they are being raised by the grandmother while Patricia is in and out of jail, the judge delivers a brutal prophecy about the future. Dramatic reveal. She tells Patricia that one day those kids will graduate or become famous, and she won't have the right to claim them. It's a transition from a legal lecture to a life lesson. The judge is trying to spark a change, but is it too late? This is the emotional core of the case. Accountability isn't just about jail. It's about the people you leave behind.
Is taking care of these children. I don't know why people continue to have children and then they want somebody else to take care of them. But I guarantee you, when these children graduate, when these children ended up being famous for whatever they've done, the parents who did not really care for them, they're going to be telling everybody on the planet, that's my baby. And you know what? Those children should say, no, I'm not. You didn't raise me. So in this court, you're not going to be allowed to be a home healthcare provider. All right, this is what the court is going to do. There's a $1,500 fine that would be probated, 4 years deferred adjudication, affirmative finding of family violence. There's to be no contact with Norma Casillas, Caslallas, and Tory, Tory Adams. There's to be no unsupervised contact with minors. Proof of employment within 45 days of release. There's to be no employment as a home healthcare provider or with minors. And there's to be no employment in the healthcare field at all. So these schools where people go to and they're there for 3 months and they learn how to take blood, not allowed. You understand?
Yes, ma'am.
There's going to be 150 hours of community service restitution. I'm going to order parenting classes. Once that's complete, 50 hours will be deemed satisfied. How far did you go in school?
I got my GD.
All right. What are you planning on doing with the rest of your life?
Honestly, working and taking care of my kids.
All right. I'm going to order, if she completes trade school, 100 hours to be deducted. I'm not requiring you to get a trade school certification, but if you do, 100 hours will be deducted. Otherwise, you're going to be picking up trash off the side of the road in the heat of San Antonio. HMAC, the Batter's Intervention Program, TAP evaluation in custody. Follow Rex. Field visits 1 time per month until further notice. Regular reporting by Zoom or in person, and regular random UAs. Probation, is there anything else?
Judge, I just wanted to, the hostility management aggression control course. It is a form of the VIPP course.
Mhm.
Both of them do have, a good amount for
Which do you think would be most appropriate for her?
the hostility management aggression control.
All right, so then I will not order the BIPP. Probation, is there anything else?
No.
Is there anything else you need from the court in order to be successful?
No.
All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
It's not.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand? All right, we can go off the record. Here's the thing. Beating up your parent, never a good thing. If you feel as though your parent has not been the best of parents to you, you're an adult. That means that, you know what, mom, dad, you were not a parent to me. So I'm no longer going to have any contact with you. But to fight with your parent, that's a no-no. Think about it. What if one of your children were to start beating you up? It's not a good thing. You need to watch the movie called Imitation of Life. It's not so much about her being physically abusive to her mom, but she was emotionally abusive to her mom. Then when her mom dies, guess what? She is running down the street, crying, telling everybody who will listen, that's her mom. We only have our parents for a small window on this planet. And trust me, if your parents are here till they're 100, it's still never enough time. Court is calling 2025 CR 001-442 State versus Patricia Adams. Can I have parties announced?
Rick Manning for the state of Texas.
William Davidson for Patricia Adams.
Are you Miss Adams?
Yes, ma'am.
Did you review the document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney? Did you understand it? Are you the same Patricia Adams who was placed on deferred adjudication in 2025 CR 001-442 for the offense of assault, family, household, or member with previous conviction on March 19, 2025 for a term of 4 years? Is that you?
Yes, ma'am.
All right, state.
Conviction under violation condition number 4. In Bear County, Texas, the defendant, Patricia Adams, who then and there failed to report the supervision officer as directed for the months of October, November, and December 2025 in violation of condition number 4.
How do you plead to that? True or not true?
True, ma'am.
The way the other two violations, Your Honor.
Any objections to the waivers?
No, Your Honor.
Did you understand by pleading true to violation of condition number 4, the court could find it true, grant the motion, find you guilty, and sentence you up to 10 years in the prison and up to a $10,000 fine?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 4?
Yes, ma'am.
Court will find violation of condition number 4 true. Is there a proposed agreement?
There is, Your Honor. That is to deny the state's motion. It's the recommendation of probation to add mental health evaluation, intensive outpatient treatment, weekly reporting until proof of enrollments in her classes is provided, and that enrollment needs to begin within 45 days from today's date for her parenting class and her hostility management.
That's what we asked for, you know.
All right, and why is she not reporting?
She told me that she was in the hospital at the time. Some of her friends were supposed to bring the records. They came, they didn't have the records. They went back to the car. They couldn't find them. So she said she was in the hospital.
Just recently, Tuesday to Friday.
No. But here's the thing. You were in the hospital Tuesday and Friday, but according to this, you missed reporting for October, November, and December. So was she in the hospital October, November, December?
Yes, ma'am. Due to an incision, I had mastitis in my left breast, and I had to have it drained. And I'm supposed to go back on the 29th for the right breast.
Okay, so if she was in the hospital, does anybody have proof of that?
I'm not sure. We might be able to. You know where it is?
I know it either has to be at my grandmother's house or somewhere in the car, but I know the car was recently impounded, so that's the only thing that's kind of trouble.
Okay.
Well, does she have a doctor?
Yes, I do. And then I believe actually Bear County Hospital can university can get all that information of me being hospitalized.
I mean, if she was in the hospital October, November, December, is she able to report? I mean, those are
No,
questions.
no.
So,
Originally, she was gonna plead on a different one, but
and why is the request for outpatient treatment?
These are the positive tests.
she's pregnant, so she is not able to go to various inpatient facilities, I'm told.
Oh, there are inpatient facilities available for people who are expecting. When is her due date?
I don't know. She says she's 5 months pregnant.
I'm 5 months. I found out I was pregnant in September, and my due date is July 7th.
All right. I'll follow your agreement, deny the motion, alter and amend conditions to include the following, and this is to take place in custody. There's to be a referral to felony drug court. If not accepted, then there needs to be inpatient treatment somewhere. And she is to begin parenting classes upon release from custody. And there's to be field visits 1 time per month until further notice. Probation, is there anything else? Is there anything else you need from the court to be successful?
I just wanted the help for the trade school. I know I had asked for that last time on probation. That's okay.
All righty, speak with probation about that and they'll help you with that.
Yes.
All right, good luck to you.
Thank you.
Sickness, Miss Reynolds,
Yes.
do you need for this to be recalled or can you go for it?
No, I could go for it. It's just, I guess, part of pregnancy.
All right. All right, the court is calling 2021 CR 8391. Do I have a prosecutor available? All right, Ms. Reynolds, I'm going to show you what's entitled Court Admonishments and Defendant's Waivers and Affidavit of Admonitions. Did you review that document with your attorney? Did you understand it? Did you electronically sign it in all the appropriate places?
Yes, Your Honor.
Did you understand your charge of possession of a controlled substance, penalty group 1 grams to 4 grams? That's a 3rd-degree felony. The range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. Did you understand?
Yes.
All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty and the court will find you guilty. Are you proceeding with sentencing?
Yes.
Defense, are we proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Yes, Your Honor. Ms. Reynolds was caught in a bad situation where she's very young and she was in a personal struggle, and these pressures caused her to relapse into use, and this led to possession charge, Your Honor. She's going through a lot in her life, and I'm amazed at how strong she is to keep it together. She recently has taken a child that she had given up for adoption, is bringing that child back into her home, which is, I know, is a very, very hard thing to do. And now she has another child on the way, and she's doing everything she can. She's going back to school, trying to get her life together.
New case, same story. Meet Ms. Reynolds. She's 14 weeks pregnant and just admitted to smoking marijuana. Reaction: the judge's line, "If you're smoking, your baby is smoking," is the ultimate courtroom cold shower. Legal insight: in many jurisdictions, testing positive for drugs while pregnant can trigger an immediate notification to Child Protective Services, CPS, the moment the baby is born. Ms. Reynolds thinks she's just answering a drug question, but she might be signing away her future parental rights. Engagement question: should a drug test in court be enough to start a CPS investigation? Let's talk about it below.
And so I just ask that you follow the plea agreement, Your Honor.
Ms. Reynolds, if you're drug tested today, what are the results going to be? And know that you are going to get drug tested today.
It would be positive for marijuana.
All right. So, when's the last time you used marijuana?
About almost a month ago.
All right. And how far along are you in your pregnancy?
14 weeks.
So here's the thing. Anything that you do while you're pregnant, your baby is doing it too. So if you're smoking marijuana, guess what? Your baby is smoking marijuana. If you're drinking alcohol, your baby is drinking alcohol. So what about this meth?
I've been off of it for about 5 months now.
And who is Juan Solis?
That was an ex-boyfriend. As
Is he the father of your child?
no, not at all.
And are you living by yourself?
Yes.
So who's the father of the child?
He's not in the picture, but I do know who he is. He lives out of state. We talk on a regular basis.
How are you supporting yourself?
I work. Well, I just quit my job. I'm looking for another job actually because of the fact that I was always at work. It was like a 24/7 job. I would get off at midnight and have to be back at work at 7 in the morning. And I wasn't able to keep up with anything that I had going on with appointments and things like that. So I ended up walking out on my job.
So how are you supporting yourself?
What I have in savings.
Is Child Protective Services involved?
No, ma'am.
But if the child that you gave up, did that child end up being in care of Child Protective Services, or you just gave
No.
the child to somewhere?
No, I gave the child because I gave the child went to a family member. Why I in the process of trying to find a steady an environment for both of us.
All right. So is the child with you now or no?
He's not with me as of right now, but he'll be returning next month. I'm responsible for him.
All right. So why is there a request for a MIC-MILF evaluation?
I'm not sure what that is.
Your Honor, there was a mental health component to this, and so the prosecutor asked to have that included in the as a part of the plea.
All right. This is what the court is going to do. Sentence you to 4 years in prison, suspended and probated for 4 years. $1,000 fine, that will be probated. $57 restitution to SAPD for laboratory testing. 150 hours of community service restitution. 40 of those hours will be waived if you provide proof of the COVID vaccination. And that includes the booster. I'm not forcing anyone to get the vaccination. Whether you get it or don't get it is completely up to you. But if you do and you provide proof, 40 of your hours will be waived. There's to be no contact with Juan Solis. I'm going to ask for parenting classes. You must complete parenting classes. If you complete parenting classes, then the remainder of your community service hours will be waived. There's to be a MIC evaluation, field visits 2 times per month, random. I'm going to want UAs for levels. There's to be regular reporting by Zoom. Proof of employment within 30 days. There's to be no employment as a home health care provider or with minors. There's to be no unsupervised contact with minors until a clean UA is submitted.
Yes, Your Honor.
Ms. Reyes, is there anything else that she needs?
No, ma'am.
Ms. Reynolds, is there anything else you need from the court in order to be successful?
No, Your Honor.
All right, I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it? And did you electronically sign it?
Yes, Your Honor.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. And also because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you want to know what the definition of a weapon is, you'll need to speak.
We're wrapping up with the ultimate mic drop from the bench. The judge acknowledges that Ms. Reynolds hasn't had the best of lives, but then she delivers a hammer. At some point, the choices you make are your own. Summary. This video is a journey through 2 women trying to navigate pregnancy, addiction, and violence within the legal system. One gets deferred adjudication. The other gets a stern warning. It's a reminder that in this courtroom, the judge cares less about your past and everything about your next move. What's your take on this, Judge? Fair or too harsh?
With an attorney, do you understand?
Yes, Your Honor.
All right, Ms. Reynolds, we can go off the record. Ms. Reynolds, good luck to you. I've read the police report, so I know that you haven't had the best of lives, but at some point, as I tell everybody, at some point, choices you make are your own. It's not who raised you or what you've been through. At some point, you can't make any more excuses. Do you understand?
Yes, Your Honor.
All right, I'm going to send you to breakout room number 1. Probation will go over conditions with you. Ms.
Okay.
Reyes, if you could just remain here for a moment till I send them to number 1, because we have one more case that's a motion to revoke.
Yes, ma'am.
On Reynolds,
Yes.
y'all can come back at 1 because the court reporter is not here. We're taking our break. Oh, I can't see you. I didn't see you. All right, so this is the last one we're doing. Are you all ready to proceed?
Yes, we are, Your Honor.
Court is calling 2021 CR 8391, State of Texas versus Monica Reynolds. Can I have parties announced for the record for the state?
Jason Garahan, Your Honor.
Defense,
I was a junior for the defense here.
are you Monica Reynolds?
Yes, ma'am.
Going to show you what's entitled motion to revoke community supervision. Did you review that with your attorney? Did you understand it?
Yes, I did.
Are you the same Monica Kayleen Reynolds who was placed on community supervision in 2021 CR 8391 for the offense of possession of a controlled substance, penalty group 1 gram to 4 grams on February 28, 2022 for a term of 4 years? Is that you?
Yes, ma'am.
All right, state.
Yes, Your Honor. Violated condition number 4 in Bexar County, Texas, the defendant Monica Kayleen Reynolds did then and there fail to report to the supervision officer as directed for the months of April and May 2022 in violation of condition number 4.
How do you plead to that? True or not true?
True.
Well, we'll waive the remaining violation of conditions.
Any objections?
No objection.
Did you understand by pleading true to violation of condition number 4, the court could find it true, grant the motion, and sentence you to 4 years in prison?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 4?
Yes.
Court will find violation of condition number 4 true. Is there a proposed agreement?
Yes, there is, Your Honor. And it is to revoke the individual off for probation, reform the underlying sentence to 2 years in the Texas Department of Corrections.
Has she done anything on probation?
No, Judge, her probation actually started about 4 months ago,
Is that true? The probation started 4 months ago?
February 28th, 2022. Started on February 28th, 2022. Oh, 22, I'm sorry.
Yes, so,
A year.
yeah, so,
I'm sorry. A few months.
all right. And you're taking something in consideration, state?
Yes, Your Honor. And, case number was CM 098 967. That's a UUMB judge. And it was pending when she took this plea.
Okay.
So that's why the state is, I mean, it should have been taken care of at that.
All right. The court will grant the motion. The court will revoke you, sentence you to 4 years in the prison, give you credit for any time served. Take in consideration 098967. Going to show you what's entitled trial court certification of defendant's rights to appeal. Did you review that document with your attorney? Did you understand it? Excuse me, miss. Excuse me.
Yes, ma'am. Sorry.
Did you review that document with your attorney? Did you understand it and did you sign it?
Yes.
All right. Because this was not a plea bargain agreement, you do have a limited right to appeal, and that is as it relates to the allegations in the motion, not the fact that you are in community supervision. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand? All right. So are y'all ready to proceed?
Yes, Your Honor. I think it was originally set as a contested. It's not
Yes.
contested.
Okay.
Okay.
Court is calling 2020 CR 3640 State versus Aisha Esparza. Can I have parties announced for the record for the state?
Martin Dara, attorney for Aisha Esparza.
And are you Miss Esparza?
Yes, sir.
Did you review the document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney?
Yes,
Did you understand it?
Yes.
Are you the same Aisha Esparza who was placed on deferred adjudication in 2020 CR 3640 for the offense of retaliation on August 5th, 2020 for a term of 5 years? Is that you?
Yes, Your Honor.
All right, state.
Violation of condition number 2
on or about the 31st day of December 2021 in Bexar County, Texas, the defendant Aisha Esparza did then and there fail to submit to drug testing as directed by the court supervision officer and or duly authorized agent of the court in violation of condition number 2.
How do you plead to that? True or not true?
True. We waive and abandon the remainder, sir.
Any objections?
No objection.
Did you understand by pleading true to violation of condition number 2, the court could find you true, grant the motion, find you guilty, and sentence you up to 10 years in prison and up to a $10,000 fine?
Yes, Your Honor.
Knowing that, do you still wish to plead true to violation of condition number 2? Court will find violation of condition number 2 true. Is there a proposed agreement?
There is a state is asking should a sentence of 2 years.
Okay. And defense, what are you requesting?
Your Honor, we're respectfully asking that you follow the recommendation of probation, which was to deny the state's motion, continue her on her deferred an extension of 2 years. They're recommending a 90-day jail sanction. That's the one thing that we differ on.
Mhm.
We are hoping that she'd be able to do a GPS monitor, partial house arrest, so she'll either be at work or at home. Additionally, I can tell you, the recommendation from probation is also alternate amend to add the drug patch for 9 months, 0 tolerance probation, ISP for 1 year, then supervised by HRC unit, MRT class, healthy relationships class, and that she will report by person for all future visits.
All right, so any objections to the court review and the court summary?
No, Your Honor.
Oh, they send it to me by email. I just don't look at it until people tell me it's okay. So let me look. All right, what I can tell everybody, the fact that probation is saying they want a 90-day jail sanction, that tells me that they really don't want to continue you, right? So what I am going to have to find out from you is why you're not doing well on probation. And it appears from looking at the probation is that there's some issues with marijuana use. I know that neither party is going on that, so I'm not accepting that as true, but I'm just telling you what appears to be going on. So you want to raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give would be the truth and nothing but the truth, so help you God? All right, you can lower your hand, state your name for the record. All right, why are you not doing well on probation?
I had a bad time in 2022 and made some bad decisions.
Why are you making bad decisions when you know you could go to prison for 10 years?
I was suffering from marijuana and from alcoholism.
All right, so let me just tell you, that's really not a good reason to come to me with that. You know why? Because I always ask everybody if they have any issues, they can let probation know they're having issues or come to me if they feel as though probation is not addressing those issues.
I understand that.
So,
And I did make a mistake.
well, no, you made choices because everybody knows you're not allowed to use marijuana while you're on probation. If you decide to use marijuana while you're on probation, you're making choices. If there is an addiction involved, for example, if you're on probation and you're using cocaine, yeah, you're making a choice, but I understand that sometimes people are addicted, right? So in this court, I always tell people, if you feel as though you're going to use, if you feel as there's an issue, let probation know. Even if you feel like, oh, I'm going to use, cocaine today. Cocaine is calling my name. I'm not going to be able to stop. I'm going to use it. I always tell them, let probation know. And then what I will do is probation will have you come in here because your attorney will tell you I've had compliance hearings and it's what can we do to get you back on track? You understand? And I'm looking at the court summary. You've been missing in action. Where have you been?
Nervous.
I don't know. Don't be nervous. I mean, I can easily say don't be nervous. I understand why you're nervous because you're looking at 10 years in prison. So I'm trying to figure out where have you been? Because I'm looking at the court summary.
I was scared to turn myself in, Your Honor.
Mm-hmm.
I did start a job in July of 2022, and I went to counseling. I was diagnosed with bipolar depression. I got on medications until I was pregnant in February of 2023. I've been doing good since, and I was just scared to turn myself in.
Well, that's a problem. All right. Anyone else has any other questions?
Your Honor, I mean,
And then, and also counsel, if you can see on the court summary, the issues with her doing Zoom office visits, if you can also address that as well.
yes, sir. I can answer some questions.
Sure.
Now you talked about the substance abuse. You talked about mental health issues. But I'm just curious, do you dispute the descriptions? I mean, did we get a chance to go through this court summary in detail?
Yes.
And you recall those descriptions of your interactions with probation on Zoom?
Yeah.
I mean, do you have, let me ask you this, was it a false representation of what happened?
No.
And do you think that that interaction at the time, what was that, well, are you the same person that you were then?
No.
I mean, you mentioned a couple of things that changed. One was getting your job, and then it was the medication as well.
Yeah.
When you got the job, that was at South Texas Podiatry. And Your Honor, I do have letters printed out. These letters are from one of the primary physicians at South Texas Podiatry. I've already shared these with
Any
you.
objection?
No objection, Commissioner.
And another letter is from Lisa Bain, the area manager at South Texas Podiatry. And a third letter from her cousin.
All right. Let me read this. And just so state is aware, I did have the defense counsel send this to me because it was in his phone to print it out, but I didn't read any of it. Okay.
Right.
So, and are these letters that the defendant provided to you?
Yes, sir. To be clear, I'm not asking for the state to withdraw the motion and issue a letter of apology. She knows full well that she made those bad choices, and that's why she's here today. But I think when you read the descriptions from the court summary talking about her disorderly appearance and her behavior, it is a completely opposite from what you can hear in the letters reflected from her employer. I mean, she has basically turned her life around totally in terms of not having any issues with drugs or alcohol. She's completely willing to be tested today and come up clean. She has basically been able to not only get gainfully employed, but make a difference at the practice where she works to such an extent that they, quite frankly, were worried that if anything were to happen, if she were to get locked up, that the practice would suffer. And I think that's reflected in the letters. They did not know about all of her legal problems until more recently. But again, they were surprised to hear about it because of the type of person, how she conducts herself. She's made arrangements, Your Honor, in the event that she weren't going to be extended on probation, on deferred adjudication, made arrangements for her kids. But at the same time, I do think that the community's interests would best be served, though, if she were to be held accountable and sanctioned, but also strictly supervised. I mean, fortunate for her, she's not a seasoned veteran, has many encounters with the criminal courts. I think she has one prior deferred on a misdemeanor case. But I think she knows right now how serious everything is. And again, what happened back in 21 and 22, I think is more a product of her lack of mental health treatment, her lack of any type of treatment for her substance abuse that she had with alcohol and marijuana. And you are correct. She could have asked for that help, but she spoke honestly today. She got there, especially after February of 2023 is when she was mostly scared about being taken away from her newborn. Again, Your Honor, you can strictly supervise her, you can hold her accountable, but you can also serve the community's interests by making sure she doesn't make these mistakes. She's completely amenable to doing a strict period of supervision. In fact, we spoke already about many of the different conditions which you could add, in addition to the ones that are being recommended by probation, whether it's field visits or, weekly meetings, the patch, drug testing. I mean, any of those things, I think you would see that she is not the same person that she was back in 2020, 2021, and 2022. It's been a complete turnaround. And I just think I would hate to see a situation where she is removed from her home. And now we have, kids without their mom. We have a young woman that's going to lose her home.
Well, I will tell you this. If you end up getting revoked and going to prison, it's completely your fault. You understand? And if you're drug tested today, what are the results going to be? All right, I want a drug test today. She's going to go to, you have your ID? All right, you're going to go do your drug test today.
Thank you, Your Honor.
All right, thank you. Miss Abrams, she is going to go do a drug test with felony drug court. All right. And can you give her the address? All right. And attachments, the court will find there's sufficient evidence to find you guilty. The court will find you guilty. Are we proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Yes, Judge, briefly. With regard to my clients, upon myself first meeting her and our first visits, I knew that there were some issues present. She's in the yellow. She is pregnant at this time, and she is charged with drug offenses, which led me to believe that there might be issues with substance use disorder, Your Honor. I did also see prostitution in her criminal history, so I did take it upon myself to ask the court previously, which was granted, to have it referred for Esperanza Court. I know Esperanza Court does great work. I've worked with them sometimes in the past, and they have evaluated her, deemed that she does meet criteria. And an email from Ms. Perez, Natalie Perez, the case manager, stating that if the court would consider granting her with the condition of Esperanza Court, that they are willing to accept her into that program, Judge. So I spoke with my client and explained the Esperanza Court's, the criteria that has to be met to get in and what would be expected of her if she is in the program. And she is willing to abide by that. She wants to change her life around, not only for herself, but for her unborn child and for children she has as well, Judge.
All right. How many children do you have?
I have 3.
And who are they with?
I gave up my daughter for adoption, and my son's with my stepfather, and I'm pregnant right now.
All right. And who is this Antonio Pablo?
That's my kid. That's my first kid's father.
All right. So I'm ordering no contact with Pablo Antonio Hernandez. And that's based upon what's in the police report. Take in consideration 2024 CR 009697, 2024 PF 17269, 2024 PF 17270. There'll be a referral to Esperanza Court. She's to remain in custody until transferred. Regular reporting by Zoom or in person, regular random UAs. If not accepted into Esperanza Court, then I want her brought back to court. So she is only to be released to Esperanza Court. When's the last time you had employment?
I have my own lawn care business.
All right, everybody's doing lawn care. Yeah, let me just tell you, that's going to stop. You're going to have a business. You understand? Mm-hmm. And when I say a business, if you're doing lawn care, you need to have a DBA and all of that. Otherwise, I'm not accepting that. You're going to have a job where you actually get a W-2 or whatever. You understand? Mm-hmm. So there's going to be proof of employment within 45 days. There's to be no employment as a home health care provider or with minors. CPS compliance. Is CPS back in your life? They probably will be, counsel. I'm going to want field visits 1 time per month until further notice. There's to be 200 hours of community service restitution. I'm going to order parenting classes. Once parenting classes are completed, the restitution will be deemed satisfied.
That restitution, Judge, is at 200.
200 community service hours restitution. There is to be 2 years in the prison, suspended and probated for 4 years. Probation, is there anything else? Is there anything else you need from the court to be successful?
The Esperanza program.
All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, good luck to you.
Thank you, ma'am.
Thank you, Your Honor. Happy
Just 1 second. All right, court is calling 2024 CR 004-712, State versus China Gonzalez. Could I have parties announced?
Megan Galloway for the state.
Michael Bellable, Mr. Gonzalez.
And are you Ms. Gonzalez? Counsel, have you received all discovery?
I believe I have.
And did you review it with your client?
Yes.
Court will find that the state is in compliance with discovery. Ms. Gonzalez, did you review entitled True Bill of Indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes, we do.
State, are you proceeding on the indictment as presented?
We move to proceed on the lesser included offense of possession of controlled substance, PG1, less than 1 gram, to the state jail felony offense.
No objection.
All right, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Did you understand the state is proceeding on the lesser included offense of possession of a controlled substance, penalty group 1, less than 1 gram? That's a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call in the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea, you were giving up those rights?
Yes, ma'am.
Did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes.
Do you believe she has a rational as well as a factual understanding of the charges against her?
I believe she does.
Do you believe she's currently competent and was legally sane at the time of the offense?
Yes, I do.
Ms. Gonzalez, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No.
Anyone promised you anything other than the plea?
No.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen? Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, the state is proceeding on the lesser included offense of possession of a controlled substance, penalty group 1, less than 1 gram. They're asking that your punishment be assessed at 235 days in the Bexar County Jail under 1244. There's an $800 fine. Did you understand that to be the plea?
Yes.
Defense, is that the plea?
Yes, it is.
State, is that the plea?
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it? And did you sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes.
Counsel, are there any such motions?
No.
Then to the offense, the lesser included offense of possession of a controlled substance, penalty group 1. How do you plead? Guilty, not guilty, or no contest?
No contest.
State, any evidence?
State offers state 1 and attachments.
No objection.
All right, state, you may be excused. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call in the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments. Court has reviewed the same. The court will find there is sufficient evidence to find you guilty. and the court will find you guilty. Are you proceeding with sentencing?
Yes,
Anything you wish to say on behalf of your client?
you're fine. Ms. Gonzalez has asked to follow the plea bargain there.
All right. If you're drug tested today, what are the results going to be? And no, you will get drug tested today before I enter sentencing.
That's fine. Clean.
All right, let's have her drug tested. All right, you're gonna,
I do go to a methadone clinic though, but that's it.
okay.
Good.
Is Child Protective Services involved?
Yes, they are. And I'm doing everything. I'm being compliant with them. I'm on my way to getting my case closed.
And who's the attorney for the children? Do you know?
I don't have an attorney. It didn't get that far.
Oh, so it's family based?
Yes.
And are the children staying with you?
Yes. That's fine.
And how often is the caseworker coming to see you?
She comes every 2 weeks. But I am also in the Esperanza program. I get drug tested every week. I have to go drug test today.
Oh, you're in Esperanza?
Yes, ma'am.
That's not my,
All right, State or Ms. Ferguson, can you look to see? She says she's in the Esperanza program.
Susan closed out and so she has.
Oh. So they don't show that you're in Esperanza Court. In Bear County?
Yes, with Stephanie at tourist stop.
All right. I believe that's Catherine Torrey.
Oh, okay.
So, counsel, before I enter the sentence, because now I have a little red flags going on. So if you could check with that court to see if she's actually in Esperanza Court. That would help the court make a decision on this. So just have a seat. He's gonna, if you go to Judge Stahl's court.
I would run down there right now.
All right, thank you. And then,
Pregnant at the current. I asked the court to follow the recommendation of the state, which is deferred adjudication in this case. It'll give us a 4-year window of time in order to make sure that she stays off the drugs and stays on the narrow path.
all right, so what's happening with your CPS case?
It's still going. I just finished one class and I'm currently on drug tests and, I'm doing good with those 3 months. And once I, do eventually get out, like I'm still gonna do, those 3 other classes
How
that
many children do you have?
I have 2,
What are their ages?
4 and 2.
And how old are you?
I'm 24.
All right. So here's the issue with the court, right? I'm going to follow your agreement, counsel.
Thank you.
But this is what you need to realize. You already had a CPS case pending
Yes.
and you pick up this case. And according to the person who was trying to help you, you've been drinking alcohol at that time and still using drugs. Do you have any idea what drinking alcohol and doing drugs does to your unborn child?
Yes, ma'am.
Well, let me ask you this, because people say that and they really don't internalize it. Let me ask you this. You're a 2-year-old, you're a 4-year-old. Would you let them drink alcohol?
No, ma'am.
Would you let them do meth
No,
or
ma'am.
heroin or anything?
Mm-mm.
Well, guess what? Your unborn baby, you're giving that child alcohol, you're giving that child drugs. That has to stop. Because I've done CPS cases before and I represented children before. And you know what ends up happening when children are born addicted to drugs? They go through withdrawals. Have you ever gone through withdrawal?
No.
All right. Well, let me just explain to you what ends up happening. What ends up happening is babies are in pain because they're going through withdrawals. They are craving what you've been giving them, alcohol and drugs. They have shakes. They are just constantly, it looks like seizures, and they are in major, major pain. So you're going to have to change your ways. If you do not, what's going to end up happening is you're going to lose custody of all your children.
That's
You
fine.
understand? Now, if you don't want to be a mom for them, you can sign your rights away.
No, ma'am. I have all of my rights.
All right. So that's what I'm telling you. You had better start looking out for more than yourself, because guess what? Your 2-year-old and 4-year-old, you can't just send them to Travis Park and say good luck to you. And when you are using and you're not clean and sober, guess what? You are sending them to Travis Park and saying good luck to you.
Yes,
That's
ma'am.
the equivalent of what you're doing. So you're going to have to change. You understand?
Yes, ma'am.
All right, the court is going to sentence you to 5 years deferred adjudication. There's a $1,500 fine. It will be probated. There's an affirmative finding of family violence. Take in consideration 2024 CC 736223, 2024 CR 009623, County Court Cause number 731512. There's to be no contact with Alice Martinez and Marina, Marina, and Zeldua. They're asking for anger management, probation. I really think it's the drugs because it appears that at the time of the offense, she was high on something as well as alcohol. So I'm not going to order anger management now. I'll hold it in abeyance. In probation, if something comes up and you feel she needs anger management, then we'll do anger management.
You understand?
Yes, Your Honor.
And
Thank
if you
you.
want anger management classes, you let them know.
Okay.
All right, there's to be a TAP evaluation in custody. Follow Rex. And I'm going to want a referral to felony drug court in custody. And counsel, if CPS has them in their drug court program, then I'll reconsider felony drug court. But for now, it's felony drug court. There's going to be 80 hours of community service restitution. I'm going to order parenting classes. Once she completes parenting classes, that will be deemed satisfied. Probation, if you can make sure that there's no overlap between what I'm asking for and what CPS is asking for. CPS compliance. Proof of employment within 40 days. No employment as a home health care provider or with minors. No unsupervised contact with minors. Regular reporting by Zoom or in person. Regular random UAs. Field visits 1 time per month until further notice. And 120 sober meetings in 120 days. Probation, is there anything else she needs? Is there anything else you need from the court to be successful?
No, Your Honor.
Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal?
Yes, Your Honor.
Did you sign it?
Yes, Your Honor.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. You understand?
Yes, Your Honor.
All right, we can go off the record. So here's the thing. This is your chance. Everybody's giving you a chance to be a good parent, to be in your children's life.
Yes, ma'am.
From here on out, whatever you do, you need to be thinking about 2 things. 1, is this something that could potentially result in me going to prison for 10 years?
No, ma'am.
You know, is this something that could potentially result in me losing custody of my children? If the answer is yes, then you should not be doing it. Do you understand?
Yes, ma'am.
If you need anything, just let the court know.
Yes, ma'am.
All right, you're
Thank you.
excused. Thank you.